We are starting now. Today is 166th Friday group meeting. The topic is documentary evidence in criminal cases. The speaker is our beloved senior advocate, former Justice Nagamuthu, present for practicing in this court as the topmost personality in a criminal law. In a Supreme Court, particularly every court has demand. Particularly recent time in 319 provision, he was sitting in the court, just they asked and overwhelming response, and he delivered within 24 hours immediately. In this is background. And before that, sir addressed our Friday group 7 times. Total contribution of viewers 1,24,000. As on date, we have viewers in Friday group in our own channel 9,78,489. As on date, 22,000 subscribers we have. As on date, 117 videos are available in our channel. Thank you very much, sir. So without introduction, because most of them, so that ये फोन हटा दीजिए भाई, आप क्या करते हैं आप? हटा दो वहाँ से. Stop that. टाइट करो, नीचे टाइट नहीं किया शायद बाबू.
टाइट है फेस अच्छा नहीं आ रहा है. इस तरफ कर दो,
उस टाइप जाओगे
उधर से कर दो तो थोड़ा ये आएगा बैकग्राउंड.
यू कम दिस साइड,
आप एडजस्ट कर लीजिए. ठीक है, क्लियर आ रहा है.
ठीक है ना.
My dear friends, before I commence my lecture, let me pray for a very happy new year to all of us. Today, our organizer, Mr. G.Seshagiri sir, has asked me to speak on a tenor important, though it appears to be a very small topic. It is, in my perception, a very important topic. Documentary evidence is common both civil and in criminal cases, that we know very well. How documentary evidence plays significant role in criminal cases cannot be simply brushed aside. Most of the criminal cases are decided on the basis of the oral evidence of eyewitnesses or witnesses who speak about the circumstances. But there are also documents involved in criminal cases. Now, what is the role played by these documents in criminal cases is a matter to be considered by us today. Now, if you look at section 3 of the Evidence Act, which speaks of proof, it says that on considering the matter before the court will proceed further. On analyzing the same, then it will give a judgment. The lawmaker has consciously omitted to say that on considering the evidence, either oral or documentary. Very carefully and consciously, in section 3, while defining the term proof, the lawmaker has said that on considering the matters before the court. Now, what do we mean by matters before the court? We know that there are oral evidences, there are documentary evidences. Now, the Evidence Act itself classifies the evidences only into 2 categories. Number 1, oral, and the other one is documentary. There is no third category of evidence at all as per the Evidence Act. But still, we have got some matters which are neither oral nor documentary evidence, but still they are to be considered by the courts. What are they? For example, In a criminal case, a pistol is produced as a material object, a knife is produced, or some other weapon is produced. Is it a documentary evidence? No. Is it a oral evidence? No. But still, the courts are considering. They fall within the category of matters. One of the matters as defined in section 3 of the Evidence Act. Likewise, you take the example of section 313 CRPC in any criminal case. We all know that the statement recorded under section 313 from the accused has got no evidentiary value at all. It is only explanatory of the incriminating circumstances put to him by the court. Now, this is no evidence, but it doesn't mean that the statement recorded under section 313 CRPC from the accused deserves no consideration. It also requires consideration by the court. But at the same time, we should keep in mind it has got no evidentiary value. It is a matter for appreciation by the court still. Therefore, there are two types of evidences. One type oral evidence, the other one is documentary evidence. So far as oral evidences are concerned, section 59 of the Evidence Act says that the evidence must be direct, right? If we keep this has got some relevance to the documentary evidence. That is why I am referring to this. Section 59 clearly states that oral evidence must be direct. Now, what is a direct evidence is also dealt with. If an occurrence, if a fact is to be seen by somebody, capable of being seen, the evidence must be from that of a person who says that I saw it. If someone comes and says, no, I did not see it, he had seen, he told me, then his evidence is not admissible because this is not direct. We call it as hearsay evidence. Likewise, if a fact is to be heard, capable of being heard, and it should be the evidence of a person who says that I heard. If someone comes to the court and says that I did not hear, he told me that he heard, then we say that it is not direct evidence, therefore it is not admissible in evidence. Keep this fundamental principle in respect of oral evidence in mind. This will help you when we are going to deal with the documentary evidence. Now let us come to the documentary evidence. So for the documentary evidence is concerned, there are two types. One, primary evidence. The other one is secondary evidence. The concept of secondary evidence or primary evidence is not known to the oral evidence, right? So this concept is known only to the documentary evidence. So what is primary evidence and what is secondary evidence? For that we should know as to what is documentary evidence first. Then what is a document? Document is an object upon which something has been written conveying some sense, or something has been inscripted that conveys some message. So it is documentary evidence. Now the original of the document which contains the message or statement is known as primary evidence, that is to be produced in court. Now the Evidence Act says that a documentary evidence, the contents of the document must be proved by means of primary evidence or by means of secondary evidence after taking in the circumstances stated in the Act itself. So the rule is that whenever there is a primary evidence available, that is the document itself original is available, it should be produced. Mere production is enough that will prove the contents of the document. Suppose the original is lost or original could not be produced, it is in the hands of the adverse party like that, then you are permitted to lead oral evidence which is secondary evidence. Oral evidence or any other secondary evidence, Xerox copy can be produced, certificate copy can be produced, oral evidence can also be let in. For that, foundation is to be created as to why the primary evidence could not be produced. These are only peripheral, this is not going to be our subject today, mainly. Now, keeping these two things in our mind, let us go to the criminal cases. Now, the earliest document that comes up in a criminal case is the FIR. Is it not a document? Yes, certainly it is a document because it contains a message, it contains a statement. It is a document. Now, you take what is the next document that is coming up? The policeman goes, the investigating officer goes, and he records the statements of the witnesses under section 161 CRPC. These statements are also documents. An observation magazine, that is Panchanama, is prepared. That is also a document. Likewise, an opinion is given by an expert. The forensic opinion is given. Postmortem certificate is there. That is also contained. That also contains the opinion, medical opinion. These are all documents. So several documents are produced before the criminal court. Now, whenever you are given the task of doing a criminal case, you have to analyze these documentary evidences which are proposed to be produced in court by the prosecution. Now, while doing that, the first question that should emerge in your mind is to find as to whether this particular document is admissible in evidence or not. First thing, if you are able to tell the court that though it is a document, this document has been prohibited from being admitted in evidence. If you are able to show that, then at the outset the document will be thrown out and it will not be considered by the court at all. So the first question. Therefore, you have to first identify whether a particular document is admissible in evidence or not. Section 5 of the Evidence Act clearly says that evidence can be let in respect of a fact in issue or a relevant fact. That's what section says, not of others. What are the relevant facts? It is not what is relevant to your mind. Relevant fact means as declared as relevant in section 6 to section 58. They are the 55. They are the relevant facts about which evidence can be let in. It may be either oral or it may be documented. Now let us come back to the FIR. This is a document I told you. Now the question is whether the FIR is admissible in evidence. First question. Now we all know generally that FIR is admissible in evidence. I give you one illustration. Here is a case where the accused, after having committed the crime, straight away goes to the police station and makes a statement which contains complete confession. He says that I went there, I shot him dead, I am coming here, I am appearing before you. This is the statement. This is the earliest information furnished to the police. Based upon this, now case is registered. FIR is registered. Now, generally we know that FIR is admissible in evidence, right? Whether this FIR is admissible in evidence is the question. Whether this particular first information statement is admissible in evidence. If this is admitted, then this itself can be the foundation to convict the accused. This is enough because it contains the confession. On the basis of this confession alone, the man can be convicted. So therefore we have to be very careful to see whether it is admissible or not. Now I will say that it is not admissible for two reasons. You have to find the appropriate provision which declares that it is irrelevant or which says that it is not admissible. You have to find out. There are two provisions which come into play in this situation. Number one is section 25 of the Evidence Act. Section 25 says that no confession made to a police officer shall be used against him. Please kindly see the word used, against him, which implies that it can be used in his favor. Is there any doubt about that? The bar under section 25 of the Evidence Act is not absolute. Bar under section 25 is limited, it is qualified, which says that the confession made to a police officer cannot be used only against him, which means it can be used in his favor. For example, suppose the accused says in his confession that the deceased came and he made an attempt on my life only in exercise of my right of private defense. I shot him dead. This is the statement made by him. This is the confession. He admits that I killed, but he gives the reasons. Now, if this confession made to the police is sought to be used by the accused, section 25 is not a bar, because section 25 says that it can be used in his favor. It cannot be used against him. Therefore, it can be used against him. So that confession can be admitted in evidence bar under section 25 is not applicable. But there is another problem now. If you look at section 162 of the code, that says that any statement reduced into writing during the course of investigation under section 161. What is the use of that? 162 says no, the said statement shall not be used for any purpose. Any purpose. Complete ban. Except to contradict the maker of the statement, that too when he is examined as a prosecution witness. Contradiction, under section 145 it can be contradicted. So that is the only purpose for which it can be used. This bar under section 162 is absolute. There are only two exceptions. That is the statement, if it falls under section 27 of the Evidence Act or 32 as a dying declaration, they are admissible. Otherwise it is a complete ban. So in the confession which I told you, that is the man after committing a crime goes to the police station, he makes a confession upon which the FIR is registered. If the confession is to be used in favor of the accused, then it will be beneficial for him, because you know very well that if a confession is made by an accused, the court shall either accept it in full or reject it in full. The court cannot make parts of it, segregate it, act upon one portion, reject the other. So in this case, the court cannot say that you who admitted in the confession that you only shot. That is enough to prove that you committed the crime. But we are not prepared to accept your explanation that you exercise right of private defense. This kind of approach cannot be made by the court, because the confession as a whole is to be accepted or as a whole is to be rejected. If the court rejects the confession as a whole, then the court cannot use it for any purpose. You please keep this in mind. Now let us go back to the statement made to the police. Now 162 of the Code of Criminal Procedure, as I told you, bars any statement being admitted in evidence, provided that statement is recorded during the course of investigation. When does the investigation commence? After the registration of the FIR, right? So after the registration of the FIR, if any statement is made, either by the accused or by the witness, that is not admissible, no doubt about that. So, but in the given case, investigation had not started, FIR had not been registered. He goes to the police station straight away, makes a confession now. This confession does not fall under section 162 or 161 CRPC. Therefore, bar under section 162 is not applicable, right? Bar under section 162 is not applicable. Therefore, it is admissible so far as 162 and 162 are concerned in the context of 162 and 162. Section 25 says confession can be used in his favor. So therefore, this confession can be used as a documentary evidence in favor of the accused. The only distinction is, as I told you, confession made to the police officer in general at any stage, either before investigation, after investigation, to the investigating officer or to some other police, whether Indian police or American police, any police for that matter. If confession is made, it is barred under section 25, but it can be used in his favor. So far as 162 is concerned, that is also a document which cannot be used in the given case where I have given small illustration. The confession was made before the commencement of, before the registration of the case. Therefore, section 162 bar is not applicable, 25 alone is applicable. Here the accused wants to use it in his favor, therefore it is admissible in evidence. As I told you, very boldly you can admit the same in evidence as a defense document. You can allow the prosecution to mark the document during trial. But while arguing the case, we can tell the court, if you want to rely on that in full. In which case, you have to acquit. The reason is that there is a right of private defense. If you do not want to act upon that, reject it in full, go to the other evidences. So this is the first document which comes up for evidence. This is the statement made by the accused to the police officer. Suppose the witness goes, after having witnessed the occurrence, he goes to the police station. He makes a statement. FIR is registered on that. Now, whether this statement is admissible in evidence or not, yes, it is admissible. Reason is, section 162 is not applicable because this was made before the commencement of the investigation. It is admissible. So, any statement upon which FIR is registered, if the statement has been made not by the accused, by someone else, that statement is that document is admissible in evidence. So, first documentary evidence in a criminal case is the earliest information furnished to the police, which is reduced in writing. Number one. Number two, I have told you about that 161 statements recorded under section 161 of the Code of Criminal Procedure. Now, case has been registered. Police officer goes to the hospital. The injured is still undergoing treatment. He gives a statement now. That statement is recorded. Is it not a statement falling under section 161? Yes, it is. Can we not say that it is barred under section 162 from being admitted? Yes, it is. But if the man who made the statement dies of these injuries, not on account of some other cause, if he dies on account of the injury sustained in this occurrence about which he made the statement, then this statement is admissible in evidence as dying declaration under section 32, because section 32 of the Evidence Act says that it is irrelevant. So it is admissible in evidence. Section 162 CRPC carves out an exception. If it is a dying declaration, then the bar under section 162 is not applicable. Therefore, any statement made by an injured or a witness in respect of his cause of death, and if the man dies later on, that statement is a dying declaration falling under section 32, which is relevant. Therefore, that document is admissible in evidence as a documentary evidence. The second one. Now, while admitting a dying declaration, there are several questions that crop for consideration. What is the cause of death? Whether the statement relates to this, that, and all that. Now, one small illustration I can give about that. There is a criminal case going on under section 304B, let us say 304B and 498A. The deceased woman, while she was alright, had written several letters to her parents, wherein she said that I was being harassed by my husband, my mother-in-law, my father-in-law, like that. She was going on writing letters. These letters were collected and kept safely by the parents. Now, she commits suicide on account of this harassment. These letters are produced in court. Whether these letters are admissible in evidence or documentary evidence, some relevancy must be found to admit the same. So, except section 32, there is no other provision under which this can be admitted. This should be admitted as a dying declaration. Now, one may ask me, how is it dying declaration? Probably a letter written long before. How is it a dying declaration? Now, if you look at the definition of the expression dying declaration in section 32, it says that any statement relating to the cause of death. Suppose the witness says that he only cut me, he only shot me because of this reason. He is in the hospital. Later on he dies. This statement directly relates to the cause of death. Undoubtedly, this is a dying declaration. Therefore, this can be the substantive evidence upon which conviction can be recorded. Now, these letters do not speak directly about the cause of death. Cause of death is hanging. Cause of death is poisoning or self-immolation. But these letters do not say anything about that. Therefore, the contents of these letters do not relate directly to the cause of death. But still, they are admissible because the latter part of the definition of the term dying declaration states that any statement relating to any of the circumstances which resulted in the cause of death, any of the circumstances. So she committed suicide under what circumstances? Because of the harassment. So the letters relate to the circumstances which led to the cause of death. Therefore, these letters are also admissible as documents, as dying declarations under section 32 of the Evidence Act. So we cannot say that these letters have got no relevance at all. They have relevance. So we have to point out the relevancy can be found in section 32 of the Evidence Act as a dying declaration. Therefore, this document is also admissible in evidence. This dying declaration. Now, there are some depositions. In an earlier case, somewhere, some kind of deposition is given. That is recorded in court. The deposition certificate copy is now obtained. It is a public document. Can this be admitted as a documentary evidence in a criminal case? Yes, it can be when it is under where is the relevance? The relevancy is found at section 33 of the Evidence Act. You may kindly consider this provision alone. I will read. Very important provision. Just see. Section 33, relevancy of certain evidence for proving in subsequent proceedings the truth of the facts therein stated. So what are they? Evidence given by a witness in a judicial proceeding or before any person authorized by law to take it is relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage of the same judicial proceeding the truth of the facts which it states when the witness is dead. Now these are the conditions. Witness gave evidence already, now no more. So when the witness is dead, in those circumstances, that deposition or evidence given recorded by him in the same proceeding earlier or elsewhere can be admitted in evidence. And one more condition is that I will tell the circumstances first. When the witness is dead or cannot be found or is incapable of giving evidence or is kept out of the way of the adverse party or if his presence cannot be obtained without any amount of delay or expense, which under the circumstances of the case the court considers unreasonable, provided that the proceeding was between the same parties or their representatives in interest. Earlier proceeding and this proceeding must be between the same parties. Adverse party in the first proceeding had the right and opportunity to cross-examine. Right? Then that the questions in issue were substantially the same in the trial as in the second proceeding. These are the conditions which are to be satisfied. This becomes more relevant when we look at section 164 CRPC statement. Let us say that there is a statement recorded from a witness under section 164 CRPC by a magistrate. The witness is the eyewitness. He completely speaks about the entire occurrence, right? He says that A1 cut hold, A2 cut, A3 shot, all these things are stated. Now that man is no more. That single eyewitness, solitary eyewitness is now no more. Question is whether that statement recorded in the very same proceeding but under section 164 can be used here as evidence, can be admitted in evidence. Answer is no. Why? Though it was recorded in a judicial proceeding, though it was recorded on oath, though it is true that the maker is no more now, but till it is not admissible, it is not relevant under section 33 because when 164 was recorded, there was no opportunity afforded to the adverse party to cross-examine. That is one of the conditions under section 33 is that sufficient opportunity must have been available for him to cross-examine. Here 164 when recorded, the adverse party is not allowed to cross-examine. Therefore, if the witness dies subsequently, that statement recorded in section 164 is not admissible. I will give you one more illustration. In a criminal case, there are 5 accused. Murder case, right? There are 5 accused. Now, 2 people are absconding during trial. As again the rest of the 3 trial goes on, there are 2 eyewitnesses. 2 eyewitnesses are examined in the first case. That is again 3 people. Effectively cross-examined. Right? By whom? By those 3 persons. Later, he dies. Those 2 witnesses die. The absconding accused are now secured. Now they are put up for trial. What is now available? The depositions given by those 2 eyewitnesses in the earlier proceeding are now available. Now in many cases, even I have argued one case here, without noticing this essential requirement of section 33, those depositions were marked here, acting upon the same persons were convicted. It is not uncommon, we have seen in our experience. So you have to look into section 33 to say, no, it is true that it was recorded in a judicial proceeding. It is true that the deposition was recorded on oath. It is also true that they were effectively cross-examined, but still they are not admissible as documentary evidence in the subsequent proceedings against the others. Reason is, these people did not have the opportunity to cross-examine. Therefore, this statement is also not, deposition is also not admissible in evidence. Be clear on this. In many a times we will be confronted with such kind of statements. So I have told you about section 32. I have said only about dying declaration. In dying declaration, which are all recorded in the documents, I have told you that what are the essential requirements which are to be proved before making them as admissible. Then I also told you about section 33 of the Evidence Act. Now, let us move on to the next stage. Let us go to section 45 of the Evidence Act. Section 45 speaks of the opinion of an expert. He gives opinion in a paper. That is a document. Now, he gives opinion in respect of handwriting. There is another expert who gives opinion in respect of fingerprints. Those opinion documents are produced in court. The question is whether they are admissible or not. Generally, there is an impression that because it is an opinion from the expert, it is admissible straight away. I would say that no. Unless the maker, that is the person who gave the opinion, it is my opinion or his opinion. The person who gave the opinion must be examined in court. And his opinion contained in the document must be proved by allowing him to speak in court. In the absence of examination of the expert, this statement is not at all admissible in evidence, right? Except section 294 CRPC, which permits some documents which require no formal proof. Otherwise, the examined. Now, what is the maker is expected to say in court? First of all, he should satisfy the conscience of the court that he is an expert in the field, right? He is an expert in the field. If he is not an expert in terms of section 45, his opinion is irrelevant, which cannot be admitted. Therefore, you can test as to whether the person who has given the opinion is a skilled person, he is an expert in terms of section 45. You can test. If you are able to establish in court that he is not an expert in this field and therefore his opinion is irrelevant, you can get the document thrown out of the court. It will never be considered. I can tell you one more illustration out of my experience. There was a murder case. I was defending the accused. The doctor was in the box to speak about the post-mortem opinion. He must satisfy the requirements of section 45 evidence. He is a doctor, MBBS doctor. He gave evidence. He said that I conducted a post-mortem, etc., these injuries, all time of death, cause, all that he said. I started cross-examining. When the cross-examination was halfway through, I asked one ticklish question. He got infuriated. He said, "What, sir? What is it you are asking so many questions? See, forensic medicine I studied when I was doing my MBBS in 4th year. I have forgotten everything. Why are you asking all these questions? Okay. Then I requested the court to record. Please record my question and answer. The judge initially declined. Then I have to make a legal fight with the judge, justify my demand for recording. Then with so much of reluctance, without knowing as to why I was insisting the court to record that, the judge recorded that. Now answer, what is the answer? I have forgotten forensic medicine, which I studied when I was a student. So you are asking all these questions, I do not know anything. This is the question. Then, as a defense witness, I summoned one police surgeon, a very senior most forensic professor, I summoned. The postmortem certificate and postmortem notes were given to her, and she was asked to give opinion. She gave opinion completely contrary to the opinion offered by the first doctor. This opinion was completely in favor of the accused. Time of death, she gives a different opinion. Cause of death, she gives a different opinion. Everything was different. Now, when the argument came, my argument was that please kindly reject the opinion of the first doctor, because though he possesses MBBS degree, he is not an expert in the field. He himself has admitted, reject his evidence. Whereas the second doctor whom I have examined is a police surgeon having conducted more than 1,000 postmortem examinations. So she is really an expert in the field, skilled person. Therefore, act upon this evidence. So this was the argument advanced. So whenever any opinion is found in any document, that is, please see to that whether the person who has given the opinion is competent to give such opinion. Whether he is skilled in that particular subject, either art, science or custom, whether he has got skill in that, then you allow him to give you evidence. Otherwise you assail. You can get that document, namely opinion, and falling under section 45, rejected by the court. This is the next document which often come up for our consideration. Then there are several such things. Now I told you at the outset that there are some documents, though they are not relevant, which are still admissible in evidence. I told you. So in other words, I can say, if any particular evidence is relevant, it is certainly admissible. If it does not mean that every document or every evidence that is admitted are all relevant. Right? Now, what are those? I will give again some illustrations and explain to you as to how they are done. You take, again go back to the 161 CRPC statement of the witness. We already told you that as per section 162 it is not admissible. Now I am going to say that to some extent it is admissible. How it is admissible? No. Section 162 declares that the said statement cannot be used for any purpose except for the purpose of contradicting the maker of the statement when he is examined as a prosecution witness. That too. Brother, here I want to tell you one more very important information. If a witness is examined either as a court witness or as a defense witness, his statement made during the course of investigation under section 161 cannot be used to contradict him at all. But this error is often committed by the advocates in court, thinking that it is after all a formal statement. No, for that we have to go to section 145 of the evidence for a moment. Please kindly look at section 145. Section 145 alone permits us to use a document to contradict. Please look at this. See, I will read section 145. A witness may be cross-examined as to the previous statements made by him in writing if there is something in writing, it is a document. So this document can be used for the purpose of cross-examining him. So if there is any statement made by him, any letter, normally we say that, did you not write a letter admitting that you received money, etc., etc. We cross-examine. Where do we get the power? Power comes under section 45, which says that with reference to any previous statement made by this particular witness, he can be cross-examined. This is the first part of section 145. This speaks of a document again. Statement in writing. Statement in writing is a document. This document can be used for the purpose of cross-examination by the adverse party. That power flows from section 145 of the Evidence Act, right? This is the first part of section 145. Then second part is very important. Second part of section 145 says, without or being, but if it is intended to contradict him, his attention by the writing, his attention must, before the writing can be proved, be called to those parts of it which are to be used for the purpose of contradicting him. So the statement which was written by him, or the statement reduced to the writing which was made by him, both these statements can be used for the purpose of contradicting the maker. That power also comes under section 145 of the Evidence Act. But one thing you have to keep in mind is, at what time and what stage this statement should have been made. The section speaks of previous statement. Previous to what? What is the benchmark? Today the man is examined. Any statement made before he gets into the box is a previous statement. Any statement made just before he gets into the box, any time before, even 1 year before, 2 years before, 1 minute before, that is a previous statement. A letter written in the past is a statement made by him. An email sent by him is a statement made by him. These things can be used for two purposes. One, for cross-examining him in respect of those contents, or to contradict him. If he does not admit the contents, then we can contradict him with this statement. Two things you may kindly consider. In the evidence that you are considering in the Supreme Court, you will find all these things. If he admits the contents of the previous statement, then there is admission, you can simply mark it. Suppose he refuses, no, I did not write like that, or he says that all these things I did not say, then the statement can be used to contradict. You just see, this you have only written, you have written like this, what do you say? This is in tune with the principles of natural justice. I make a statement today. I know why I am making the statement. 10 days before I made a different statement on the same subject. So I know as to why I made such kind of statement then. I am changing the same, I am making the statement today. So you have to ask me, the adverse party has to ask him, afford him opportunity. It is by way of principle of natural justice that I will be in a position to say, under these circumstances, I made that statement. Under these circumstances, today I am making this statement. I am offering an explanation for this contradiction. So based on the contradiction, it is for the court to act upon that or to reject it. Now we have been saying in court that there are a lot of contradictions, there are a lot of contradictions. Alright, there is contradiction, what if? So what, there is contradiction between the 161 statement and the evidence. Yes, alright, it is there. What if? FIR contradicts his deposition. Yes, alright, what if? There is contradiction. What do we do out of that contradiction? That you will find in section 155 of the Evidence Act, which says that one of the ways to shake the credibility of a witness is by proving the previous contradictory statement. That means you can contradict the witness at 145, but you have to prove that letter. You have to prove that part of the statement. If you prove that part of the statement, if you prove that contradiction, then what is the result, end result? The credibility of the witness is lost. You can say that is also provided in section 155 of the Evidence Act. So ultimately what we do, using this documentary evidence, namely previous statements, we request the court to discredit the witness who has given oral evidence now in court. He used oral evidence. So you see the interlink between the oral evidence and the contradictory, the documentary evidence. Document is used here to destroy the oral evidence of the witness, right? So that is the way in which section 145 allows us to use a document, though it is not relevant, though it is not declared as relevant, still it is admissible to some extent to contradict or to cross-examine that witness. By proving, I will put it very simply, by proving the previous contradictory statement. Under section 155, we compel the court to discredit this man who says so many things in court on oath. Discredit, don't believe him. That's what we say, right? Please understand this 145 scope. Here again, there is a friction between documentary evidence and oral evidence. Then there is a cohesion between oral evidence and documentary evidence. That you will find at section 157. 157 is also an important provision which all the young lawyers should know very thoroughly. It speaks of corroboration. In court, very often we see that there is no corroboration. We argue in court, there is no corroboration. What do you mean by corroboration? Where do you get all these things? Corroboration means it is not defined anywhere. In no statute, what is corroboration is defined. But in course of time, we have interpreted, we have understood. Corroboration means nothing but supporting evidence. It may be documentary evidence, it may be oral evidence. Right? It is nothing but a support. One thing is said now. The question is whether this can be believed or not. For that, when we feel that it is somewhat shaky, we look for some other evidence which will corroborate, which will add strength to this. That is corroboration, nothing more. So corroboration is not required in every case. There are two aspects in it. There are statutory provisions which say that unless this particular evidence is corroborated by some other evidence, don't rely on that. Don't make complete reliance on that. This is one way, which is provided statutorily. The other one is by judgment law. When the evidence of a witness is somewhat shaky, it doesn't satisfy the judicial conscience of the court fully. In such an event, the court, as a rule of prudence, it is not rule of law. The first illustration which I gave is rule of law. Statute itself provides for. The second one, this one is not rule of law, it is only a rule of caution or rule of prudence. That is looking for corroboration in a given situation is nothing but a rule of caution or rule of prudence. Right? I'll give you one small illustration for this also. See, under section 114 of the Evidence Act, in one of the illustrations it is said that the evidence an accomplice is unworthy of credit. Right? So what is the presumption in law? There is an approver, he is the accomplice. The presumption fundamentally is that he is unworthy of credit. It is not by means of convention. It is not at the discretion of the court. It is by virtue of the operation of law. Section 114 says, going by the human conduct, it says that an accomplice is unworthy of credit. Right? That is a presumption. It further adds, don't act upon that unless it is corroborated in material particulars by independent evidence. So statutorily provided for corroboration. So whenever there is an approver, examined in court, there is no other evidence at all, no other evidence to corroborate. We can boldly tell the court, here is an approver, he has been cross-examined, he could not be shaken at all during cross-examination, but still, this is not sufficient to convict the accused. Don't convict based on the evidence of this approver. That will be our argument. The court has to look for corroboration from independent sources. Section 114 illustration says the court has to, as a rule of law, look for corroboration. Right? The second illustration which I gave was that here is a case where there is solitary eyewitness. Very often we say there is only one single witness, whether there is no corroboration. That is not the correct approach. It is not as though corroboration is required in every situation for every witness. So for this you can look into the judgment, a very celebrated case of this honorable court in Indri Vadivelu 1957 Supreme Court. Look at the judgment. A witness is classified into three categories. Witnesses are generally classified into three categories. The first category is a witness who is fully believable. Cross-examined, everything done, absolutely nothing on record to disbelieve. Fully believable. Second category is a witness is fully unbelievable, completely, turns hostile, etc., etc. Third category is a witness who is partly believable and partly unbelievable. Now this honorable court has said that so far as the first category and second category are concerned, there is no difficulty. If the witness is fully believable, no corroboration is required. This by itself is enough. Suppose the witness is fully unbelievable, no difficulty, we can simply reject his evidence. When the witness is partly believable and partly unbelievable, the difficulty arises. So as a rule of prudence, the court should look for corroboration in respect of that witness alone. Right? Therefore, there is no point in generally saying in court that there is no corroboration, there is no corroboration. There is no point. You have to point out. Single witness, partly believable. Two witnesses, two accused have been acquitted. He has been disbelieved. There are 5 accused, single eyewitness, 2 have been acquitted, disbelieving him. Which means what? He is partly believable. When he is only partly believable, partly unbelievable, you should look for corroboration. There is no corroboration, therefore acquit. It's a good approach in a case. Instead of saying that generally I require corroboration, there is no corroboration, there is no point in that. You should point out pinpointedly that too, as to how the court, as a rule of caution or as a rule of prudence, should look for corroboration, in what circumstances. This also you have to say. So here also again documentary evidence comes. Now I was referring to section 157 of the Evidence Act. Section 157 speaks of corroboration again. Of what? Any former statement. Right? Understand this. Any former statement of the witness can be used to corroborate him when he is examined in court as a witness. So whether any former statement, you see the different language used in section 145 and 157. In 145, the language used is any previous statement. Therefore, I said previous means previous to his examination. Right? Now, stopping for a moment, I will give you one more illustration. Here is a case where one witness is examined. He has been cross-examined, right? Finished. After 1 month, he is examined elsewhere in a different case. In that case, he says that in the earlier case I did not see anything, but I gave false evidence. He admits it. When after 1 month he gives evidence in a different court, in a different case, during cross-examination he says that in that case I gave evidence as though I saw the occurrence, but I did not see the occurrence. Whatever I said there is absolute falsehood. Now this witness is, in this case, recalled. Question is, can you use that deposition here to contradict him? No. Because it is subsequent statement. It is not prior statement. Then what is the use of that statement? That statement of the witness can be used only under section 313 CRPC as a matter. Okay? So I told you, as per section 3, the court is required to consider the matters before the court, not only evidence, matters. Though it is not evidence, it can be considered as a matter. Therefore, you can produce that deposition record in some other case here, not making it admissible under section 145, but as a matter falling under section 3 of the Evidence Act, and you have to produce the same by using the procedure under section 313 of the Code of Criminal Procedure. Very scientifically and technically you can do that. But here you will invite the court. You just see, this deposition was made only by him. In that case, where he has said that he did not witness this occurrence, please look into that. You can request the court, but it is not by way of contradicting him. So that is why I said that the statement which is sought to be used to contradict must be previous in point of time, just 1 minute before getting into the box, not any statement subsequent. It does not mean that the man is free to say one thing here and say something else there and we are helpless. The law helps us. The technique we should know as to how to bring this also on record and how to request the court to act upon that. This is the way in which we are bringing. Then you look at section 155. 155 speaks of a former statement, not previous statement. Consciously a different language is used. Any former statement made by that witness can be used to contradict or to corroborate any former statement. But there are two conditions. You look at section 155. There are two conditions. One is, in order to corroborate the testimony of a witness, any former statement, kindly look at any former statement made by such witness relating to the same fact, at or about the time when the fact took place, or before any authority legally competent to investigate the fact. So the statement should fall either in the first category or second category. Now I throw a question to you for your discussion, for your consideration. The statement recorded under section 164 CRPC, right, from a witness, can it be admitted in evidence for the purpose of corroboration? Undoubtedly it is a previous statement, therefore it can be used to corroborate. That document can be used to corroborate. Contradict. No doubt about that. Because section 145 does not impose any restriction. You are free. Whereas section 155 qualifies it by two conditions. One, the statement should have been made at or about the time when the fact took place, or it should have been made to an authority competent to investigate. Now, whether the magistrate who is recording the statement of 164 is competent to investigate? No. Therefore, we can tell the court, don't look at that 164 statement, don't use it for corroboration. Right? Here is an approver who has given some statement earlier. He would have given confession. Whether that confession can be used to corroborate. This error is committed up to this honorable court in several cases. Whether it can be used to corroborate him. The question is whether this confession falling under section 164 can be brought under section 157. I would say that it cannot be brought under section 157. Therefore, that confession, when he was accused, he makes a confession. Now he has been taken as an approver. Whether that confession can be used to corroborate him now. Now, if I am asked to answer this question, my answer is very clear. First of all, this is not admissible in evidence because they hit by section 162. If it was made to the first confession made to the police, hit by 162. Confession made to the magistrate, it is not admissible because it doesn't fall under section 147. Therefore, don't look into this. If it is a confession, even now, it can be brought under section 30, under section 24. Now he is a witness, he is not an accused. At the time when he made the statement, he was accused. It was confession. Now it has lost its character as a confession. Now it is only a statement under section 164. Therefore, this is not admissible, is my view. I will leave it to you. So, in the matter of approver, the confession made by him when he was an accused, in my view, is not admissible in evidence. I leave it to you for your further consideration. I am not so sure whether I am right or not. I am only telling telling my views, and it is for you to decide. This is yet another document, sir.
Yeah, no, sir.
So, likewise, there are several documents. I can speak about I have said about the confession, I have said about the expert opinion and forensic opinion, then handwriting expert's opinion. There are so many documents. How to assail the handwriting expert's opinion, how to assail the handwriting expert's opinion, how to assail the ballistic expert's opinion. These are all great subjects, very interesting subject. They are all relating to documentary evidences, opinions contained in documents. So what is the relevancy of these documents? To deal with those subjects, our friend Mr. Rao doesn't allow me. Reason is that we have already crossed 40 minutes time limit.
1 hour, sir.
Thank you so much. Thank you so much.
Thank you very much, sir. New Year to 2023, we want to begin with you. Really excellent. Sir immediately accepted and he has given. We want to begin with you, sir. That's what my request. We accepted that. We are very grateful.
Thank you.
So, this, I request Ahmed will give a vote of thanks. Yeah, please. Remove that.
Justice Nagamuthu is a very known personality and he's contributed all of his life in serving the judiciary and to the bar also. So right now he is among us and chosen to be a speaker in our Friday group. And really we all admire whatever he has contributed today and really so much impressed. He illuminated all of our senses in the light of evidence. And his specialty in the criminal law is a tremendous thing. And we are very thankful that he shared his this legal acumen among all of us members. And really Friday group really thankful to you for your lot of precious time you have given over here. And thankful in every aspect which you have contributed to our Friday group. So nice of you, sir. Thank you so much.